Aaron grew up in Connecticut playing basketball, and if you ever met Aaron in real life, you'll know why. And working a little for his grandfather land surveying. He ended up in Sonoma County, California in 1991, working for Adobe Associates and became a managing partner in 2001. He's licensed in both California and Nevada and was a CLSA state president in 2010. Aaron has served as the delegate on the WestFed board, worked for the BORPELS with exam and review and development, and has been able to present land surveying topics such as business, legal descriptions, record of surveys, and other topics at various venues. Aaron studied business administration in college and is still a managing partner at Adobe Associates in Santa Rosa, California. Aaron has been married to his wife, Jennifer, for over 25 years, and they have two children, 23 and 19. And without further ado, we appreciate your time and for leaving your golf tournament early. I'm sorry about that, but we appreciate you talking about some legal descriptions.
Yeah, thanks, Trent.
Thanks, Aaron.
First of all, thanks for that bio. A couple of housekeeping items. The material that I'm presenting, I don't do this professionally or for a living. So as you can see, I settled in on this PowerPoint that I did in New Mexico back in 2013. I've given some of these same topics in Idaho, Utah, Arizona, Hawaii, back in Louisville, or as I say, Louisville. So please plagiarize, steal, do whatever you want with my material. I don't care. If you get something out of our dialogue today, that's all that I want. And even if it forces you to just think a little deeper into your own process, for me, that's great. As I mentioned, I don't ever charge conferences or groups or organizations to do these topics or seminars. All those places I listed, I usually just paid for my own travel and did the seminars. And the reason being, I believe in giving back to the profession that's been so good to me. And, I want to, thanks Trent, you too. And that's where I really want to give some kudos to Trent. I've known him for, I don't know, maybe 12 or 15 years. And Trent, you're super dedicated to this profession, like super dedicated. And I know it's rewarded you well, and it's because you work on giving back. Yes, and I think everyone that's on this seminar, and I can see some of the names, and they've certainly given back to the profession. And I urge each and every one of you, when you get the opportunity to mentor, to give back to someone else, when someone asks you to step up and maybe chair a committee or maybe even CLSA or NOWS or your local chapter, do it. The one thing I learned when I went through the chairs at CLSA State is that I had this great big safety net under me. There were some awesome, awesome people who were just committed to not letting me fail. And so don't be afraid. Take a step forward, challenge yourself, and I can almost guarantee you that when you step forward and take on that task, you'll be rewarded like you wouldn't think that you would be. And then you're giving back. And then as you give back, other people give back to you. And it's just a great cycle. So Trent, I applaud you for everything that you've done over the years and will continue to do.
Thank you, sir.
And I appreciate that. So here today, we're going to talk for, I don't know, hour and a half, 2 hours. My goal with you is not necessarily to teach you something, but if I can challenge your thought process, then I've done my job. If you walk away from here going, I disagreed with absolutely everything Aaron said, everything, I don't mind. Send me an email, reach out to me, because with legal description, there's a lot of it that is sort of style. There's a lot of it that is questioning how you would approach qualifications, how you want to describe it. Is this a situation where maybe I should go counterclockwise versus clockwise? But if you really sit down and think about the legal description itself and think about what are you trying to accomplish, then you'll start to spark some thought. And the next best thing is to ask your boss, ask a friend of yours, ask someone at, CLSA or NOWS, or I don't know, Trent, if you got any others from out of state, but wherever your local surveying community resides. So my hope today is to challenge you, not to teach you, but to spark an interest and go, that was interesting hearing about that approach. It was interesting to hear why they describe something a certain way. So that's my goal. So if you got onto the workshop hoping that after today you'll get a certificate through the master's program of legal description writing, I'll send you a certificate. I don't mind. It'll be signed with my name, and it'll be as useless as the toilet paper is actually not useless, but it'll be close to that. So anyway, that's my hope. Some of you have maybe heard me speak before. I love live audiences because we can really read and feed off of each other. But I'll hope to go through this as well as I can. As Trent sort of alluded to, I was at a golf tournament and I left a little bit early, which is okay. I'm not very good at golf, but I donate money while I'm there. So, so I left a little early. So I have a water in one hand and I have some hydration in the other hand. And Trent, I hope that's permissible on your forum and you won't get dinged.
100%.
That's great. Here's the other thing. A lot of what I use is Waddles. Let me just give Waddles a shout out. So Waddles is my favorite book, hands down. I'm not saying it's the best book or it's the book needed for your particular situation, but every new surveyor that comes into my company, I buy them a copy of Waddles. And here's why. It's a simple read. It's a good read. It won't bore you quickly. And it teaches you about all elements of surveying. So Waddles will go through, rivers and oceans and streets and aliquot and sectionalized lands, the lot and block and strips. But he's also talking about boundary situations. So if you read it carefully, you're learning about boundary and you're reading about legal descriptions. And at the end of the day, a big part of our job is to read legal descriptions and try to understand it. So that's why if there was a new surveyor coming up and they said you can only take one book to your island before you're deserted there for a year, which book would it be? For me, it would be Waddles. And so I just want to reiterate, I'm not saying that Waddles will answer every one of your questions. And if you're into a real touchy, tricky situation, maybe it is Brown or some other book or Flushman's, water boundaries, or of course, the BLM, the manual. So make sure you hear that. That I'm not saying that Waddles will answer every question every day of the week. I'm just saying, for those of you who are really trying to figure out what is surveying and how do I take all of these pieces that I've learned, construction staking and field surveying and a little bit of topo, and what does this all mean to a project? Then I think Waddles is a great place to start for a foundation. So I have hopefully one or two spots in this slideshow where maybe we'll take some questions. Right now it's about 4:15. This presentation I did in New Mexico was, I think, like a 3.5 hour presentation. So I'll try to speed things up or slow down. And I went through this presentation a little bit and reviewed it, but I might be flying by the seat of my pants a little bit. So forgive me. If you hate everything I said, just ask Trent for your membership fees back. Right? I mean, Trent,
right.
I mean, you're probably charging thousands to become a member of this program.
That's right.
And sorry while I hydrate through this. Usually surveyors are hydrating because they had a tough day at work, and sorry, I'm hydrating because I had a tough day on the golf course. Okay, so here they are. Here's another book too. You know, there's great books. Everyone will have their own ideas. If you work for an LS or other people in your department, ask them. Be inquisitive. That's the biggest thing as a surveyor, be inquisitive. The other thing I want to say too is, you know, as a surveyor, don't be afraid to reach out there and ask someone. We were all really dumb idiots at one time in our career, and we just were fortunate enough to talk with people who mentored us and helped us climb that ladder. So I think, you know, one last little spiel is I do believe that surveyors were taught to be independent thinkers, right? we're taught to go out and make some field measurements and analyze the evidence and calculate the deeds and make a decision and then map it and then record it. And it's our decision and it's our license and it's our liability on the line. And that's all true. But I just wish surveyors would be a lot more collaborative at times. And I personally think there's ego and arrogance in the way. Part of that is what's taught to us. You know, you go to these seminars and you hear the oh shit stories about, you know, someone being sued and, you know, liability and risk. I just want our community to work a little more collaboratively. If you can honestly sit here on this mentoring Mondays and tell me that you've never made a mistake or that there's not a boundary out there that to this day you question, then I would challenge you on that. But that's why, for the good of the public, let's continue to work together. Didn't mean to hijack those few minutes from you, Trent.
No, that was perfect. I love every bit you just said there. That was perfect.
Yeah, great. So there we go. Legal and legal description pertains to the fact that the description must be able to withstand attack under law. That's true. But first, it must withstand the attack under peer review. And don't think of attack as a bad word, but just remember, how many legal descriptions are you reading that were first developed at the turn of the century or the 30s, 40s, 50s? You know, I just turned 50 this year, and maybe by the time I'm 60 or 65, I'll no longer be surveying. And I'm going to leave behind a great wealth of work product. And make sure that those people following behind you can really understand what you are trying to describe and what you are locating with your description. I think these are all quotes right out of Waddles. Sorry, I should have put a footnote about that. I didn't. Parole or extrinsic evidence may not be admitted to add to or vary a description that is definite and certain, nor may it be used to explain an apparent ambiguity in the conveyance. So I think a lot of people say, well, the surveyor's job is to survey intent. Absolutely. You know, I don't want to cast a shadow of a doubt on that. But as people have said in the past, the heaviest weight of intent is a well-written legal description and an agreement between two parties that describe a piece of land. And I'm actually working on one or two that it's clear, I think, what the intent was, but the description started in a location that is a movable object, shall we say, a river. So it's hard to retrace the boundary when the point of beginning moves every year. So, so again, when the description is definitive, you know, all of those extra things that we want to use to work our boundary back into the deed dimensions, and just be cautious. Legal description should be clear and concise. Your slogan should be concise clarity without ambiguity. Well, there's a good slide. If there were hands raised, I could answer that. So what is a legal description? A legal description identifies a unique piece of land with only one location. And I said, identifies a unique piece of land. Someone might say, well, what about an easement? Is that really identifying a piece of land? No, it's kind of describing a right over a piece of land, though. So, usually you've got the preamble, the body, basis of bearings. We'll get into that a little bit about most agencies want an explicitly written basis of bearings. But if you read any good legal description book, the basis of bearings comes right in the very beginning of the body of your description. It controls your bearings. And a bearing is nothing more than a difference in angles, right? So you start with north, and if it says go north 45 east, well, that's 45 degrees off of the line you established as north. And maybe when you establish the section line, it's north 1 degrees east. So it doesn't mean that you should go north 45 east still. Maybe you should turn 45 degrees off that line, making it north 46 east. So we'll get into basic bearings a little bit more. Not explicitly writing it within the description. Here's some references for wattles. This, of course, is California. That's where I do 99% of my work, even though I'm licensed in Nevada. I think I've signed 2 maps in Nevada. One was kind of a fun project with Matt Gendrich and some of the guys. So sign, seal, date, so on. I am going to gear some of this discussion towards those who are looking to take their LSIT and their LS exams. I think that's important. What is your legal description trying to accomplish? I really encourage people to make a plot of your field drawing, of all your points, whatever you call that drawing, and then sit down and point to the lines, point to everything that you're about ready to describe, and think hard about what is it you're trying to accomplish at the end of the day, and what should control along the way. And I believe you can change your basis of, I don't want to say bearings, but your basis of turned angles throughout the legal description. And we'll get into that a little bit further. Okay. Are we describing an easement over an existing use, such as a utility line or paved or road driveway, over a proposed route of a utility or road driveway again? Should we, the land surveyor, encumber the easement with rights? I'll get into that. If you're working with an attorney who's developing an easement agreement, be careful, because the attorney could work with you and say, hey, Aaron, we need a easement for road, utilities, and gate access. And so in your preamble, you maybe copy what he wrote in his original agreement. Now, all of a sudden, the landowners get together and they say, I really don't want a gate. And the attorney removes it from his agreement, but he calls you up and says, Aaron, your legal description is perfect. Sign and send it back. And yet your preamble matched his previous rights. And so now you've encumbered it with a gate. And so now the legal agreement doesn't say a gate, but your preamble might say a gate. So my recommendation is, if you're working with legal counsel who's developing the agreement, then just write an easement over the lands of so-and-so, more particularly described as follows. Let the document itself encumber the property. Will our description be part of a legal document? That's what I just went through. Review, practicing law, see attachment. So a lawyer in California, and I would have to imagine it's somewhat close in most all states, is that they're the ones who are allowed under their license to put two people into contract and an agreement, right? It's what they call a legal covenant or an agreement or a binding agreement. And if you really look at it, that's what an easement is. So for surveyors that are actually creating the easement document and the legal description, we always create a plat with our legal descriptions. If a client says, no, I'd rather save $200 or $500, I say, tough, it's my document. I want the plat with it. So a lawyer is supposed to do that. I think that that's one of those lines that can get blurry, especially if someone's just saying, look, I want to grant my son a ingress, egress, and utilities easement over my road to get to the back property. Well, use your judgment, but easements are one of those things that can be easily litigated because it'll come down to interpretation later on. And of course, hopefully the dad and son won't get into a lawsuit over something, but it's the people beyond them. So just look to see what is practicing law, and you might find that a lot of grant deeds and easement agreements fall under the purview of a lawyer. Are we describing something unique? Completely understand the ultimate goals and desires before writing. Well, if you have someone that's just calling you out of the blue and says, I just bought this property, talked to my neighbor, they're willing to give me an easement for this well. It's going to be a 20 by 20 square, and it's going to have a 10-foot strip connecting to the property line. That's great. Don't just go out there and locate the well and the property line and say, oh, I'll have this legal description to you next week. Find out more about it. I think this is where surveyors can do a much better job. Don't just be a surveyor, right? You know land, you know how properties work, you know what can happen in the future. So help that person, right? Understand the infrastructure. What about the maintenance? What if a new well has to be drilled? What if the F-250 has to drive onto the property to put a new pump in? What are all those things that you can help have a discussion with? And maybe they have good legal counsel that will give some guidance. And for everyone that says, well, I hate working with lawyers, here's what I tell you. You haven't worked with the right ones. Because when you get working with a good land use attorney, you and that land use attorney can really brainstorm and have some good dialogue and really come up with great solutions. And if this person is saying, look, I can't afford a lawyer, I just want to hire a surveyor for $2,000 and write a legal description and put it together, well, at least inform them some of the challenges you might have in the future if you don't really think about it today. At least in 10 years, if there's some litigation matter, someone can go back through your emails and say, wow, this person at least tried to push them in the right direction to think about more than just a legal description. Is there something that we want to make sure doesn't happen with the description? And we'll get into this a little bit further, but sometimes you know for sure you want to stay away from a tree or a building, then we want to make sure that we recognize that. Whatever you do, describe it in such a way that we don't end up describing something by mistake that causes a problem in the future. And I know there's a lot of discussion. Well, if you go out there and locate the corner of the house, isn't that a monument? Now you got to file a record of survey? I don't know. I would say no, because you can write that legal description that says, you know, up to a point that's 5 feet south from the existing barn, and then east, you know, parallel with the existing barn. That doesn't require a field survey, but a couple of measurements doesn't hurt either. So that line should be, if you write it correctly, 5 feet off that barn, no matter what type of field surveying you've done in the future. Trent, if there's any burning questions, you'll probably just wave at me or something, huh?
Yeah, anybody can unmute themselves as they go along. And then,
Oh, perfect.
Yep. And there's,
Hey, no F-bombs yet. That's pretty good.
well, Rob just jumped on, so he might.
Oh, well, there it goes.
Yeah.
Rob,
There goes the neighborhood.
Yeah, there goes the neighborhood.
Here's something I love that we'll talk about. POB, TPOB commencing. So let me just go through this and I'll give some of my own surprises or some of my own thoughts. You commence and then go to a POB, or you can begin and then go to a true point of beginning. So you can't commence and then go to a true point of beginning. It's just when you read Waddles and some other literature, the correct way is to commence and then go to a point of beginning, or begin and then go to a true point of beginning. Up till about 2009, I always began my descriptions, beginning at a iron pipe, marking the corner of lot 8, and then blah, blah, blah to the true point of beginning. I was pretty diligent about making sure when I went back to the point of beginning, it said back to the true point of beginning, not back to the point of beginning. So our old county surveyor, Gary O'Connor, he and I had a great discussion one night for about an hour at his office. And he really showed me that it's easier when you commence and then go to a point of beginning. It's easier to differentiate that, and it avoids some confusion later and even possibly a mistake. And so there I was as a professional talking with our county surveyor, having some really nice dialogue. And he changed my opinion on how I should write these things. And so now I do commence and then I go to a point of beginning. I usually also commence at a known monument because we're trying to describe a piece of land or an easement or a figure, and you want that figure to be retraced without any ambiguity. And so that's why I started, trying to always commence at a monument from which another monument bears. That gives you 2 solid monuments. Don't commence at an iron pipe monument, knowing that the affordable housing project is going to be built next summer and more than likely going to wipe it out. Try to have a little forethought in some of this. I'll go into it a little bit further, but I was working on a project in a local city, and about 30 years ago, they wrote a resolution for a new street, and they began at a centerline monument from which another centerline monument bared. And then the surveyor had a tie to the corner of block B in the city block, and then went down and around. And another surveyor came through about 3 years ago, and he decided that he has a better understanding of where that city block is. It's an old city block, 1860s. And from that city block, it was a different location than was recited in that legal description. But since that legal description cited to the city block, they changed their orientation. And I believe that when you put in the geometry and ignore the call to the city block, even though it was there, but when you come off those 2 city monuments again and you retrace that street, I think there's a little better fit. Now, we went up 1,000 feet with all these courses. The difference came out to be about a 3-foot rotation. And I talked with the other surveyor, and they were about 99% done with all the design of that city street, and our project was just tying in off of it. So he was correct in saying that, look at the deed called to the city block. And so when you decide to call to a city block, but it's your interpretation of where that city block is, just be cautious. By that call, you could have, based upon another surveyor's opinion of where that city block corner is, you can change everything after that. But I know where that street was supposed to be based upon two city monuments that haven't moved, been in the same spot for 50 years. Why not just come off of that and run your traverse? But, you know, everyone's taught to make all these qualifications and descriptions. You know, one of my old business partners, he really likes beginning at the south line of the lot from which the southeast corner bears, you know, east 100 feet. But if that's not monumented or marked, if someone has a different opinion of where that southeast corner is in the future, well, that changes everything of where that easement is. And let's just say it's over a road. Well, that could have just changed everything. Someone will get into, you know, the analysis of, well, if he says thence along the approximate center line of the road, I get it. It still gives you wiggle room, but I have changed a lot of my philosophy since I first started and since I passed the exam on how I write legal descriptions. I don't really care about boundary lines anymore. What I care about is retraceable monuments that can retrace my legal description. Now, when you hear me say that, you know, for those people that fell over in their chair, please come back, because I'm not saying, you know, screw boundary lines. I'm just saying, if your job is to retrace this figure, then retrace it off of known repeatable locations, a physical monument in the ground. Don't recite a corner that isn't theoretically marked with a monument that someone can't go to touch and sniff. And here's the next thing. Sure, can that surveyor call that monument off a foot? Absolutely. But shouldn't they still use that monument to retrace your description? And then, of course, you might not be on the boundary line, so you got to figure out what to do and how to connect and tie into it. But anyway, these legal descriptions, I've changed a lot of my professional outtake on those by just having good philosophical discussions with people. But to be honest, those are happening at the CLSA and the NOWS conferences. Those are asking someone, hey, Trent, here's a weird deal. What do you think about this? And, you know, and going over to Steve Martin and saying, what do you think, you know, from a public utilities easement? What would you like to see? And you start to get this breadth of information. And you start to go, wow, let me decipher all that and find my own way. And what you'll end up doing is you'll grab some tools from everyone's bucket and you'll find your way on how to describe these things. And, you know, I'm going to be meeting with a local utility tomorrow because I got a legal description back and our project manager said, I've never seen so much red on a legal description in my life. And I said, either have I. Yeah, I got it right here. I mean, if you can see it, I mean, I'm like, and after I went through all of it, it was style. And I will tell you, like in my preamble, I say a public water easement over the lands of so-and-so, blah, 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 you know, as shown on a map filed in the county, blah, blah, blah. And then I say beginning at a point on the westerly line, and in my body, I recite the ownership name again. And here's why. Title companies. I don't know if we have any title people on here. I don't mind telling them this, but they screw us all when it comes to title reports. Because they say, Aaron, love your legal description. Can you send it to us in a Word doc so that I can just clip it into the title report? And guess what they never clip in? That darn preamble. And so they write in there a 20-foot water line easement as described. And then you're saying beginning at the northeast corner of said lands, because your preamble told you which lands it was at. But now you got a title report. And for all of you who don't know how it works, title company comes up with the title description, your Schedule A in your title report. They take that, they transfer it to a grant deed, and the grant deed is what gets recorded. So now you've got all this historical information that's lost. And a lot of people will tell me, a lot of jurisdictions and municipalities say, that's a duplication, please erase that. And once I explain to them my reasoning, that that body description will get cut out and put into a legal description, I can't lose the preamble, especially when the preamble says, you know, beginning at the westerly line of so-and-so, and also being lot 8 of a subdivision map and as shown on the record of survey filed in 2009. All of that is pertinent information to the retracement of that legal description. And if you don't know that, the title company just removed all of that critical information. So for me, I duplicate it. And it's great because once I get my preamble perfect and I double check it and I know it's good, I just copy it out. And then I say beginning at a point on the westerly line of so-and-so, and I just paste that back in. So you'll hear me say, I'll do a copy, cut, paste, whatever, but I also hate the damn command because if you ever look at your survey maps, right, topos especially, someone has copied over, you know, found half-inch iron pipe, no tag, elevation 100.0, and then all of a sudden, all 6 iron pipes on their property are at elevation 100, and you just go, come on, people. So in some sense, I like the copy and paste commands, but as soon as you copy and paste something, edit it. Don't just say, well, I'll come back and I'll edit them all in one shot, because you'll miss it. And then the licensed professional signing the map, when the client comes back and says, are you sure all 4 of my corners are at the same elevation? I said, what are you, calling me an idiot? Yep, I am. All right, let's talk about the basis of bearings, either incorporate into the legal description or by direct recital. So I like both. The first call in that legal description establishes your basis of bearings. I will also be honest with you, and I know I might take a lot of flack for this. I don't believe in basis of bearings. Sorry. Most all of our survey measurements are based upon an angle, not a bearing, right? So my earlier example, due north, then you turn north 45 degrees east, that's a 45-degree angle. So if you establish this line between the 2 monuments as something different, then that angle is 45 degrees. And I'm not even about to get into the conversation about true and direct and assumed and all the different norths and souths that we can come up with. But if you begin your legal description and you say begin at the northeast corner of lot 8 marked by a pipe, and then, you know, west along the north line 200 feet, thence leaving it and going due south, well, that's a 90-degree angle. So if you're doing a big survey and that line is not due east-west, that's fine, but that's 90 degrees. And all of your calls after that can have an angular relationship to that line. So you can then, in a direct recital after that, say the basis of bearings is between the 2 pipes measuring east and west on the north line of the lot, you know, as said in your body of your description. So our county surveyor in Sonoma has taken, I think, a great approach to basis of bearings, and it's have you given me 2 points that you say you measured between them is this bearing? And I'm like, that's great, because a lot of times you don't even need to be rotated to a proper basis of bearings to define your boundaries that you're doing. You know, if you have 2 pipes you found here and 2 pipes you found here and some other monuments, you know, those monuments are controlling the lines, not necessarily the bearing. And then if there's a couple monuments missing, you're probably reconstructing them based upon the relationship of those monuments, not necessarily a true bearing from the map, unless you're on the map bearing.
Hey, Aaron.
Aaron?
Yeah, I
Yes.
was gonna say, Ian wants to chime in.
Yeah, Aaron, this is one of my pet peeves, basis of bearings. And one of the things that I have a real problem with is in a well-crafted legal description, you might have 3 or 4 basis of bearings for your survey. And where I have a problem is if you start off with something that, for example, you're going from the quarter corner, then northerly along the west line of the northwest quarter section, up and up and up to the northwest corner. You created that as a basis of bearings, and then you turn and you go another bearing along the north line of the section. If that north line is measured in the field slightly different, what you're saying is the first basis of bearings is the west line, then you switch over to the north line, then you switch over to the east line of the quarter section, then you switch over to the south line of the quarter section. But if you put a single basis of bearings in that statement and there is any error in the measurements of those things, now you're saying, I change the basis of bearings every single time, and then the real basis of bearings for this is just the west line of the section. What do you do with the discrepancies in the other two? So you're actually creating an ambiguity if you put that direct basis of bearings reference in there. I would much rather see somebody who's competent looking at a legal description going, I can follow the basis of bearings around this puppy anytime, as opposed to the incompetent person that says, well, I need to have that basis of bearings explicitly stated or my head will explode.
Yeah, and you bring up a great point, and you're spot on, is that anyone who's reading this stuff who has a level of competency should understand that the description you just gave me, each one of those 4 lines is controlled by something different. And if in the middle of that description you suddenly veer off and just describe something around an existing well, then that basis of bearing should be based upon that prior recital of that line. And so, Ian,
Exactly.
you're correct. It's like looking at a record of survey, and that surveyor surveyed the section line 5280 apart, and then there's a pipe that he calls 500ths off the section line. Anybody who's been around long enough knows that that surveyor did not call that pipe offline. I mean, you'll get some people who go, yes, he did. Look at 500ths. No, he did not call it. He just made a measurement of that day, and that's what his reported recording of that measurement, but there is no way that surveyor actually called it off, if that makes sense. And I would say the same thing with the legal description. If I read that legal description that you just wrote, and then I saw a direct recital of that basis of bearings, I would say that that basis of bearings is informational only. So if all section corners are gone except for that west line, okay, maybe that base of bearings has a little more weight to my retracement than does something else. And I think these things that you bring up are all of these great opportunities in why I love this concept of mentoring Mondays. It's an opportunity for people to start to hear this stuff. And if there's anyone on here that all of a sudden is going, okay, they just went way over my head with this discussion, that's okay, because we've all been there. Keep digesting it and find those people that you trust and say, hey, what in the hell was Ian and Aaron talking about? And maybe their boss will take them aside and start to show them what the development of that legal description is. PG&E, they will not record an easement without a direct recital basis of bearings. I get it.
They will when I don't do.
Yeah. Well,
but the other takeaway from what you were saying, Aaron, is the great thing for all the people who are listening to this who are not yet licensed. One of the things that you heard Aaron talking about was sitting down with the county surveyor for Sonoma and going through that Dave O'Connor. If you call me and say, hey, what am I doing, or can you help me? There's no way I'm going to tell you, no, you're not licensed. I'm not going to talk to you. Absolutely call me.
Yeah.
That's where we get paid. That's why I get paid.
Yeah. No, I wish people use their county surveyor more. I mean, I see Carrie is on here and she works with our county surveyor, and I have great dialogue. Matter of fact, her and I were texting back and forth the other night about it. It was a useless detail of a project, but her and I got into this trench and we're like, hey, what do you think about this? Well, I don't like it because of this. And, you know, we had some good dialogue out of it. And at the end of the day, it didn't mean a rat's ass, but we had great dialogue, and it was an opportunity for us to hear different viewpoints. I know with Carrie, I can call her and have a discussion, and I know that she doesn't feel threatened. And I know when she calls me, I don't feel threatened because we're trying to just have a dialogue to get to the best outcome. There's been one or two projects that were really tricky for me and my clients in the county. I went to the county surveyor and said, you know your ordinance really well. My understanding with this and the Subdivision Map Act, is this a good way to skin the cat? And 90% of the time I was right. And we modified 10% of the approach because of the input of the county surveyor. It was great. So back to my earlier point.
Hold on one second, Aaron. Steve had something he might want to kind of on the same topic there.
Oh, good. Yeah.
Go for it, Steve.
Martin?
Oh, okay. Yeah, Aaron, you mentioned somebody marked up your legal description. I hope that wasn't East Bay Mud.
No.
No, but I can understand that to some extent, with a dedication to East Bay Mud, ultimately the utilities are going to own it. And so they want it, written the way in their style, essentially, a style that they're comfortable with. And also just want to say, it's usually not the LS that's checking these, it's somebody working on their responsible charge. So they don't have as good of a feel for all the different stylistic interpretations for it, so they're maybe have a boilerplate that they're checking against. But, I do want to mention one time, one of my guy checking was gone, and I looked at one myself, and it was okay. It was okay to me, except the one thing looked odd is he had all the radial bearings going towards the radius point. And if you read Waddles, radial bearings radiate from, the center of the arc. And so I pointed that out, and boy, I mean, you would have thought I'd insulted his heritage or something, And he made a big fuss about it, and I said, okay, it's not worth fighting over, and any surveyor is going to be able to figure this out in the end. So we did accept it. But to me, it wasn't the standard, but he'd been writing it that way for 30 years.
Yep.
That's awesome.
No, and Steve, you're correct on that. I will admit, I changed my style based upon the latest tools. And today we work in a world of AutoCAD. And so if I wish AutoCAD would figure out how to be a little more user-friendly with curves. But that's why now, a lot of times, if it's a non-tangent curve, I am calling to the radius point, right? So that you can go out to the radius point and then easily turn that angle and turn that curve. And to your point, Steve, what gets me about review, and Carrie and I had this discussion years ago, is what she would say to me is, well, Aaron, half of my markings, I would get 10 marks maybe back on a big map. And she says, well, half of those are just, some input or feedback for me. I'm not telling you have to change it. And I go, well, when I see red, that's a quick indicator that you want that changed. So she's now changed it to where red is, hey, I really want this changed. And green are some suggestions. And I've worked at Adobe since 1991. Since I'm an owner, I'm pretty sure I'm not going anywhere. So I've been able to learn from within and these four walls. But Steve, people like you and county surveyors, they see a vast majority of styles. And I love hearing back. And a matter of fact, that's how Gary O'Connor started that conversation with me. He says, you ever consider this, Aaron? So I just think that when the municipalities or jurisdictions, if they have some suggestions, we should be receptive to that. But one of my concerns is for me to go through all of those marks, and I did for an hour and a half, and I was like, well, only about 15% of them really impact the legal description. My only problem is it's delaying the project from getting permitted, and it's costing my client thousands of dollars. And so if you were on the other side, would you want to spend thousands of dollars on your marks? That's what I would say. In our discussion tomorrow, I really want to understand why they want some of these stylistic things. And Steve, you made a great point. At the end of the day, it's going to be yours. So you'd like it in a special format in a way to do it. That's great. But maybe also explain that. This is a jurisdiction where I've only written about 2 descriptions in the last 5 years. So it's a little bit further away from our office. Anyway, getting off topic a little bit about that. This is what I hope people are hearing is pick up the phone, have a conversation. Let's not butt heads because we're professionals. Most professionals that I have ever interacted with, they really do want the best outcome for the general public, for their client, for the project. They are not trying to be antagonistic because they have an ego behind it. Now, for our government employees, right? You may see a much different animal than that, and I respect that. You probably have seen some real doozies come across your desk, but I wish that would change a little. So, thanks, Steve. I appreciate that input. Because you're right. Let's see. So here we go. Free calls versus qualifying calls. Pretty simple. The free call is just that straight bearing and distance. So maybe you're leaving the south line of your property and now you're just going north 100 feet and north 45 west 100 feet and back northeast 10 degrees east, 100 feet. And then all of a sudden you tie into the property line. Well, all those calls in between are what we call flat calls. They're just a bearing in the distance, nothing controls, no monuments were set. And then the end point is where it is. Again, going back to the very beginning, make sure you're thinking about what it is you're trying to control. And at times, maybe you need to recommend to your client, let's file a record of survey on this. And in California, I know, if you're monumenting an easement, just an easement, that doesn't require a record of survey. But, if you're going to tie it to a boundary that isn't shown on a record of survey, now you got to think about, am I obligated to file, a record of survey? I know one I did a couple of years ago, a nonprofit wanted me to write a bunch of legal descriptions around development areas and no touch zones and where a possible septic area could be. And I monumented all those. And I had 2 good Caltrans old 6x6s on Highway 1. I tied between them for a tenth. They were about 1,000 feet apart. My descriptions began about 600 feet up the road. And so I just used that as my basis of survey, went to the middle of the lot, set a couple of rebar and caps so that they could be retraced, made some notes in my legal description about it, and we were able to monument it. If you're tying into a boundary that needs it, then you've got to use your own professional judgment at that point. But that's what we look at with the free calls. Qualifying call, different pieces to that. There's the physical object. pipe, tree, street, river, axle, etc. Describe them just as you would any other monument. I'm starting to use my legal descriptions now to give a little more information on it. Like I sometimes make a note at the bottom of my legal description. The monuments that I describe as found were done through a survey in July of 2021 by Adobe Associates. You know, that gives someone now a little bit of information about questions if they have it. They know, hey, let's call Aaron over at Adobe and see what's going on. Maybe I made a mistake. Maybe we said a monument incorrectly. Well, now they know who did it, and now they know that maybe they can call me and get a little more information on it. So it would be helpful. At the qualifying calls, whether it be to a physical object or a legal boundary, the bearing and distance then become informational, and the qualifying object holds. Careful on double qualifications. You know, I've retraced a couple of surveys. I'll give you a very interesting story. About 12 years ago, I was retracing a lot line adjustment that was done, and they said beginning at the south line from which the southwest corner bared 200 feet, and it was marked by an iron pipe, and they described it. And then they said, and from which the southeast corner bared 200 feet. But when I measured between them, there was a 5-foot bust in his measurements. So now I'm like, okay, that second qualification, if I use that monument, then that line goes right along the edge of the well house. And so I called the surveyor and I says, why did you do this LLA? And he says, well, to get that well house onto the property. And I explained that there was a 5-foot discrepancy in the measurement, and I went and measured that line 3 times because I don't believe I'm perfect, and I don't have any expectation that my surveyors will be perfect. And we're running out of here with 4 to 6 crews a day. So I went and double checked the measurements, and there was 5 feet. The problem was the surveyor said, well, I really can't give you any more information. You'll just have to use the legal documents that got recorded to solve it. And all I was trying to say is, where did you intend to put that line? I believe he intended to put it 5 feet off of the shed so that the zoning would be okay. He wanted to give me that tidbit. So that's where I ended up putting it, because we got in touch with one of the old owners and he said, yeah, that's what we were trying to do. So, but his double call, if I could have just relied on his first call and then took off, but he tried to put another call in there. And I'll be honest with you, if I'm beginning at a point, but I've tied 5 or 6 monuments around, and I want to give you that information in case some of those monuments go missing, I put them on my plat for informational. So if my point of beginning pipe gets destroyed, well, you can use the other information and maybe put it back and then rely on my point of beginning. But if in the legal description, you're now saying, beginning at a point from which the southwest corner bears and the southeast corner, and then I tied the pipe at the northeast corner, and then all of a sudden, like, what's our point of beginning based upon which monument? So be very cautious on your double qualifications. I know a lot of people are asking to put notes on the plats that say that this plat is for informational purposes only, and the legal description holds if there's any conflicts. Let me ask you, when you go retrace a mistake that came out of your office, which one generally is correct? For me in my office, the plat. Because maybe I'm sitting here writing the legal descriptions, and I still write about 80% of our legal descriptions, and I don't plat them. But I miss it. I miss the quadrant. I went 45 degrees instead of 55, but the plat, because I developed the line work, is generally correct. And so when you put that note on that plat, that says this is for informational purposes only and the legal description controls, I don't know. I have heartburn over that. I'll be honest, because I find that the plat generally has a greater level of accuracy, right? But the scholars will say, well, your legal description controls. Okay, why can't they both control? Why can't they just work harmoniously together? And if I can derive the error by using the plat instead of the legal description, I'm going to do that. And if someone wants to challenge me on that, I'm okay. I'll explain why. And someone might say, I'm worried about an attorney for the most part saying, well, what about that note? The legal description holds. I go, yeah, but there's an error in the legal description. Well, we can get into all the law about, well, now you've identified an ambiguity or an error. Now we can go outside the four corners of that document to try to resolve it. Trent, that's a whole nother mentoring.
That's a whole nother presentation.
Okay.
I like it.
That's,
That will be a good one. Rob wanted to chime in real quick.
Aaron, are you having your up and coming staff review things for you to try and make sure there aren't inconsistencies between your legals and your plats?
I ask every one of my staff to check my work because I am not the smartest critter on earth. However, my staff, like most staff, is running fast and furious. So they may have glossed over the same error that I did. So in my office, I generally will write the legal description, and I'll either write it from the plat they developed, or I'll write it and then they develop the plat. And the reason I don't plat is I have no idea how to really use AutoCAD beyond boundary analysis. So all this drafting and stuff, unfortunately, I can't do anymore. But yeah, Rob, to answer your question, yeah, we have checks and balances. Most of the time, things get caught, if not by us, by a reviewing agency, which is great. God bless them. They're checking things with a fresh set of eyes. And then sometimes everyone misses it, and then it gets recorded. So, yeah.
There was one more in the chat. There's a couple of following along, but Jen says, if the deed refers to the plat, doesn't that incorporate the plat as part of the legal description anyway? So
it does, but on the plat, you know, our jurisdiction carries on here. Her and I have had this conversation many a times. They want that note on the plat that says this exhibit is for graphic purposes only, and the legal description still controls. I asked the attorneys I work with to list as described in Exhibit A and further depicted on Exhibit A-1 or Exhibit B, however your office does it. And I have control, but when a reviewing agency says, no, we need to have that note on it, well, I mean, my project doesn't get recorded unless I put the note on it. So my hope is that if there's an obvious error, then obviously the plat gets to come and play in the team, you know, but I think it's one of those things where have some dialogue and discussion with your reviewing agency. Have a good discussion about the why or why not about it. And it's amazing the things that you can learn from your reviewing agencies, because they're seeing 50 different surveyors work in a year, right? Carrie, is that right? Give me thumbs up. 50, or is it higher? Is it higher? Yeah, maybe 100. I don't know. I can't count past 5, so I have a hard enough time with that. Okay, so we've talked about double qualifications. Really, this is talking about give some thought to those monuments you want to use, and don't be quick and dirty about it, and make sure that someone can retrace your figure. And if your figure can be retraced by the 2 monuments or the 4 monuments that allow that person to retrace it, but maybe it's not touching the boundary line by 6 inches after you do that in-depth analysis. Well, I don't think you should change the figure to rotate onto that boundary line. I think maybe you should consider extending the sidelines down so that you don't screw something up on the north, or rotate that strip description to a point where, 5 feet of that road is now outside of your easement. If you can properly put the geometry of that based upon the monuments, maybe you should consider extending the south easement lines 5 feet down to the property line, or a foot, instead of a drastic 2-degree rotation or something. Again, this is the joy and the privilege of being licensed. To this day, practicing for 20 years, I have not seen the same boundary survey as I did on the exam. That nice section that they give you coordinates, or that monument that controls. I haven't come across that nice, tidy boundary like is on the exam. So you get to think and process after you get licensed. Here we go. Okay, here's my favorite, to a point, right? We've all read those legal descriptions, right? It says north 10 feet to a point, then east 20 feet to a point. I'm like, okay, well, if you read the definition of what a point is, it's the end of a line. So no need to say a point. Second thing about the word point is this should be an indicator to a point from which the northeast corner bears 100 feet. So every time I see a point, I'm looking for something after to help control that point. So if we're traversing up to the north line, and then we say, north 100 feet to the north line of lot 8, from which the northeast corner bears 100 feet, well, that point now gets to come over 100 feet from that iron pipe because you called to it. So now you want to be careful. Is that really what you want to do? Or do you want to begin at those 2 monuments on the south, and you traverse that road really tight? Well, don't give a call over to that pipe because it could adjust things. Now, if we're all making good measurements, it's going to make, a 1/10, 2/10, 5/10. Maybe if your measurements are a little sloppy. Okay, maybe not a big deal, but maybe put that information on the plat so that if 1 or 2 of your monuments are destroyed, they can say, well, look, they measured over. So just remember, Waddles is really good about the definition of a point. And that's where I got this information from. So if it's just flat calls, just call them as flat calls. Along a line, to a line. Clearly describe the line. Property, right-of-way, fence, center line. State the direction of travel. Sometimes I'll say then leaving the southerly line in a northeasterly direction along an existing 10-foot wide gravel road. At least you can then give a quick direction. State when you leave that line. I typically will say that, thence leaving said line, northerly, with a bearing and distance. This is interesting. Most books that I've read, when you call to a street, means to the center, unless qualified. River, creek, center, or thowwag. Helping some property owners and some attorneys in an adjoining county try to understand their deed calls to the center of the river, and how are we going to establish the center. Depositions were taken by 3 surveyors, and from what I understand now, there are 3 positions. So after each deposition, the attorney I'm working for calls and says, well, he said the only way to locate it is this way and this way. And I said, well, that's interesting. There's definitely some books that we can get into more detail. Identifying the center of the river in this issue is not the crux of the problem. It's something much bigger somewhere else, but I think they just want to understand some of that. So just understand when you're calling to the center of the river, what is that? One of the things I told the legal counsel, I says, these deeds were written in the 1800s. And there wasn't a municipal water system that delivered a 1-inch water line to your property and gave you a meter and you turned on the faucet and all the abundant water came out. So you have to remember that these rivers and creeks were used for cattle. It was so critical to survival that your cattle could get to the water. So maybe the thou wag is something to consider, because that would give each person that last drop of water if their cattle needed it. There's other notions. We get into tidal and non-tidal and navigable and where to. Again, another Mentoring Mondays. Talk about water boundaries. Parallel with, not parallel to, that's just grammar. You're parallel with something, not parallel to. So parallel to is coming into a line. If you're running parallel with, you never intersect, in theory. The road is parallel to with the river in the same direction, but always the same distance away. Line parallel to another, draw parallel to this line. So again, these are all great things to be considering when you develop your style for writing a legal description. And once you think you've got your style pinned down, then go to the next conference and have a discussion with 10 different surveyors and see if they won't change your mind on some of your style. I know I've changed my style probably 4 to 6 times since I passed the exam. And if anyone has taken the exam, figure out your style way before you get to the exam. And let me just give you an example. If you're beginning at the northeast corner of Lot 8, are you beginning at the monument that supposedly is marking the corner, or are you beginning at the corner that's marked by a pipe? I'll leave you with that. But if you really want to dig deep, those could be 2 different positions. And I don't know, think about it. But don't get into the exam all flustered now, thinking, okay, what's my style? Because then you'll get all flustered and you'll make error after error and probably not do well on the exam. So write tons of descriptions. When I did it, every weekend, I went and grabbed 3 maps that we had done surveys on 10 years ago. I took the map home and I wrote a legal description around the property. And then I had my LS review it, and he gave me great feedback. And when I got to my LS exam, I wrote it and I felt very confident. I don't know, Steve Martin, you were probably grading back when I took my exam, and you probably read it and said, holy shit, really? Send this guy back to kindergarten. But there's Steve's laughing. See, I knew I was right.
I only graded 1 year, so probably not the last year that they graded.
Yeah, I'll admit I graded a few years, and sometimes I'd read descriptions and I was like, is there any way I could get this guy's name? Because I really want to offer him a job. Like, yeah, not a chance. Which bears and from which? Define the point of reference. Clearly state the bearing and distance from the monument or point of reference. Do not double call. Go through waddles on this. Be very careful. If you're beginning at a point from which the southeast corner bears, that's a tie. Or you beginning at a pipe from where the point of beginning is. There's all that language in there, and make sure that you're stating it properly in the way that you want it to control. Okay. Again, if you have someone else to review stuff in your office or a reviewing agency, they might be able to point some stuff out. If you're sitting in the exam, these are just those little things that you want to feel comfortable with. the exam, at least when I took it, it was only once a year, and it was nerve wracking because you're like, if I screw something up, you're sitting a year. Now the rules are different. I think you can take it a couple times a year, and it's computer-based testing. And man, that was a shindig going up to Sacramento every year to take that thing. I took it 2 or 3 times before I passed. I was young. The first time I think was in '98 when we had, I think, 11 people pass that year. Whew. Let's see. How are we doing on time? Not bad.
Yeah, you're okay.
To a point of curvature, again, I think Waddles wrote this book in the 60s. So some of this nomenclature may have changed. I know my partner, he used to always write, to the beginning of a curve to the right being tangent from the preceding course. I think every legal description book I ever read was if you go into a curve, then the previous course is tangent. It's taken as tangent. So you don't have to state that. He still feels comfortable just reiterating it. I'm going, great, no problem. I do not any longer. I just go into the curve and I say a curve to the right, because I'm thinking AutoCAD, easier to navigate that. To solve a curve, you only need 2 elements. I think most everyone gives 3 elements. It's always a great check. And then if it is non-tangent, Steve pointed out, it can get really tricky on describing a non-tangent curve, right? The one that always gets me is the tangent bearing, because Steve, like you said, the tangent bearing is the bearing as though the tangent kept going. I'm always thinking it's the bearing that I just came from, but you almost have to go out that tangent bearing, flop 180, and then come into it tangent. So it always gets me. So if you're stuck on some of the nomenclature, make sure you close the entire deed mathematically to make sure that you went the right direction on some of those curves. Don't get stuck. Here's a good quote. So in writing descriptions, use words and phrases that clearly convey the intent of the parties concerned without creating any need to resort to extrinsic evidence for clarification. That goes into the earlier quote where it says, you're really not supposed to go outside the 4 corners. We talk about intent. You got to survey the intent. Well, if the deed is perfectly written, the deed is locatable, the deed is retraceable, and there's no issues within the 4 corners, then are you really supposed to survey intent, or are you supposed to just survey what the deed says? That's what's always gotten me, is because we're taught as surveyors, always survey the intent. I'm going, okay, so if the deeds are perfect and the monuments fit, are we really surveying intent, or are we just laying the deed on the ground? So here we go. So we talk a lot about this. If you find conflicts, I try to give as much information. Look, I'm a very prideful surveyor, and I think if you're on this Zoom, you are too. No one likes the phone call saying, I think there's an error in your work. But I think we need to recognize that there's going to be errors, and good professionals will have that discussion with you and not make you feel like a dumbass. So anyway, I just keep bringing these things up is because after 20 years of surveying as a licensed professional and 30 years with this company,
Yeah, Jason's got a comment.
Oh, go ahead, Jason.
I agree. I was working in GIS after I worked in land surveying, and I was doing some reading of documents and came across a description that didn't match the plat. And it was because someone had copied and pasted, like you had mentioned earlier. And I called the guy and said, hey, I just wanted to point this out. I'm trying to close this traverse, this boundary here, but it's not working. And can you just look at it with me to make sure that I'm not making a mistake? Because I'm not a surveyor, but I'm experienced enough to know better. And I just wanted to make sure before I made some phone calls that, you got a chance to look at it. And he appreciated it because it was exactly that. Someone had just copied and pasted a distance, and it was busting at like 365.5 feet, and it was easy to fix. However, the bigger problem was it was a vacation of a few streets and a few other things, and it took 6 months to get it signed. So he wasn't happy in the long run, but ultimately it got fixed. But I appreciate the comment, because yeah, if you approach it professionally and not try to embarrass somebody, I think you can make a lot of headway. And it was very successful for me in the few times that I was able to find some blunders or mistakes that just fat fingered it, and it was easy to get it fixed. But it just, if no one says anything, it just sits there until someone goes, oh wow, you really screwed up.
Yep.
Yeah,
Yeah, and
good stuff.
I guess I'm in a soapbox, but I've been in places where surveyors were not very receptive about their work. They say, "Oh yeah, just call me, let me know." But in all honesty, no, they don't want to hear from you. And it's I totally appreciate that. Not to say that I don't hang up the phone and go, "Shit, that's a bummer." And I talk with my staff. I preach, don't copy. And what I should do is put a jar on my table and just say, you got to put $1 in every time you copy and make a mistake. So, um, what I always try to do with my staff is find a way for them to put skin in the game, right? And because once you have some skin, right, some legit skin, you start looking at things a little differently. And I used to talk to my field crews, and they'd make some mistakes, and sometimes I felt like, was that a lack of knowledge or was that a lack of effort? And if I identified it as a lack of effort, yeah, I'd bring the two of them in, and I would say, hey, person A, what I've decided to do is if you ever make this mistake again, ever, I'm going to fire your partner. And they look at me and they go, what the hell did you just say? I go, yeah, that'll put some accountability behind you, because if I fire you, you might go home and say, oh, well, I don't like the job anyway. But if you force me to fire your partner, then you'll start to think about it. Oh, and by the way, your partner will then start looking at your work and say, hey, did you screw that up? I don't want to lose my job. So it's really interesting. You just see their look on their face sometimes. And I go, no, I'm only kidding. I won't do that. I like you guys. But it goes back to that accountability. Love my magic 8-ball. I use that so often. Suggestions. Preamble should clearly identify the source of title by location as well as vesting. The biggest thing is, and I have this discussion with title companies and stuff, is my job is to properly identify the figure, right? So sometimes we get stuck with, well, that deed recorded a couple days ago, but my legal descriptions are already in and they're stamped and recorded, and they're going to be combined with a document. I go, well, that's fine. I'm not transferring title. I'm describing an easement. So there's some really philosophical conversations about that. I know Waddles is one that'll say, you really make sure you understand the title before you describe it. I might agree with that, but I also say, well, my job is to locate something. So regardless who owns this parcel, if I'm qualifying to the northeast corner of lot 8, well, that's a retraceable spot. It doesn't matter if Joe or Tom or Harry own it. It's a repeatable spot to begin your legal description. Description of preamble should also clearly identify its purpose. Like I said, if you're working with an agreement, just make sure you're in sync. I mean, I know my old business partner, he's been retired for a few years now, but he really liked stating the purpose. But there was 1 or 2 times I remember where the attorneys worked out the purpose differently than it was stated. And years later, someone called me and says, okay, am I allowed to have utilities in this easement? Because utilities was one of the things that easement took out based upon the agreement. And I says, well, I don't know. Now we got an interesting situation. So my basic view is if I'm working with an attorney who's developing the easement agreement, I just simply say an easement. And I don't encumber its uses. I let the document do that. My job at that point is to provide a location. Exhibit class, we've talked about that. Keep it simple and straightforward. I agree, but I've been putting more information into my plat so that people retracing it can maybe get a nugget of additional information in case a mistake is uncovered. At least who I am or the company that did it. That's great.
So
proof your work.
we've
Yeah.
had cases here in Northern Nevada, not to interrupt, but where we always put a title on the legal description, like, okay, it's a proposed parcel, for example. And then in the heading, we restated that because we found out several times that people would kind of white out the proposed in the title and record the doggone description, and that put us in violation of NRS.
That's right.
Creating an illegal parcel. And I think California's got about the same rules because I think we copied you guys. But it's kind of a scary situation. I mean, you don't know where that thing's going to go after you stamp and sign it for sure. So you need to be sure that you put enough in there to make sure that the purpose is understood beyond just putting it in the title.
Yep. That goes back to my preamble where after it leaves your hands and title companies and other people get a hold of it, and now with all this fancy, sophisticated PDF machines, they can. I will give you my perspective, and I've been an owner of this company for 20 years. When that document leaves my office, I'm sorry, people are going to do things to it. And if they chose to do it, I just got off the phone with an old client from about 5 years ago. She took my plat and she sketched on there a proposed exclusive use easement. And then she tried to use her own language in an easement grant. And she tried to save about $1,500 on my fees for replatting it and helping her describe it. Well, the property was at an angle. She drew a rectangle, but the other property came off at an angle. So she's got this little triangle she doesn't have access to. So before she gets to the easement that she reserved back for herself, she's got to cross this triangle. And can I tell you, like 5 people had a discussion with me. They were livid that she would plagiarize or use my document and PDF it. I'm going to be honest with what I said. I don't care. I'm sorry. The document left my hands. In 30 seconds, I went back to my file. I pulled up my original document. I said, here's my work product. If someone took it and hacked it up and did something with it, I mean, and this is what I told the attorneys on the phone. I says, hey, I'm not going to get my undies in a bunch over this. Now, if someone sued me because I didn't do good, accurate work and I left a gap in the easement, my goodness, could you imagine me in front of a judge and I show him what I did? And then I said, the property owner used their PDF machine and made their own mistake. I'm not going to be liable for that. So my business partner and I talk about that with contracts and liability. But quite honestly, it's pretty obvious what our work product was. And I just don't get all worked up over it. 2 surveyors from my office, they were rallying the coup, right? They were pitchforks and all. And I went, why? They basically hung themselves. Now, here's what I get to do, right? I can go fix it for $2,500. There's my business and marketing background that I have from school. I now say, boy, people always pay more for problem solvers than they do maybe creators.
Yeah, that's true.
Anyway, Sorry, I
Well,
didn't mean to get off on a tangent, George. You know, you're
That-
right. There's-
That's our job, to solve problems, not create them.
yeah,
But
sometimes-
I would agree that you could go back and pull up your work product and show what you did. But it's still embarrassing when you get that call from the county surveyor and the recorder saying, "Hey, what the heck are you doing here? Why is this way?" So we just found a simple way to solve it. We just made sure we put enough purpose in other parts of the description to make it so it couldn't be edited.
Yeah, you know, you're right. Hey, George, think about one other thing. They had a 5-minute conversation with you and you cleared it all up, right? Think of hours other people behind the scenes took trying to figure out what a bumbling idiot you were for violating all your statutes instead of just going, shit, I know, George, let's give the dude a call. But
Yeah,
no,
exactly.
guaranteed there were hours spent trying to understand why this guy was such a dumbass in violating the statutes. I love those scenarios. And I love it when the attorneys tell me this whole journey that they've been on for the last 6 months, and I answer their question in 5 minutes, and I go, does that do it? And then I remind myself of George Washington. I'm going, boy, I wonder what that 5-minute call is worth. Okay, 4 attorneys at $500 an hour, spending an hour, that's 2,000. So I don't know. I'll just send a bill for $2,500 and we'll call it good.
Well, I have to say, I did have an advantage in that situation because I'd worked on the same survey crew with the county engineer for about 4 years, and he knew better. He knew I knew what I was supposed to do, and he expected me to do the right thing, and he was very happy to hear that I had.
Yeah, right. So that's where we are with technology, right? I keep my stamp, right? I don't use it very much, but my official stamp, I keep it in my desk drawer. And you know, my old business partner, he's been surveying a long time. He gets all flustered because people have access to my digital stamp and digital seal. And I say, really? What do you think they're going to do? Come in on the weekend and do some stupid hairball thing? I hear stories. It happens throughout the country, but not here at our office. We do enough vetting with our staff. And then I told him, shit, Paul, I've known where your stamp has been for 30 years. I've never touched it. So I think sometimes we as surveyors, right, we get that anal retentive vision and we can't get out of our own way sometimes. And I'm going, okay, someone took a PDF document and kind of played arts and crafts with it. Whatever. Document preparation review, title company or other third-party prepared documents, in-house prepared documents, make sure your title data is up to date. You know, just make sure you're doing some preparation on the current deed, especially with in today's society where there's LLCs and other people owning interest, and maybe you missed 1% owned by little Johnny over there. So do the best you can on your title. And if you can, get a title report or the title policy. Of course, I was looking at this going, oh, this would have been nice to have in the beginning, right? Okay, here's your 5 typical types of descriptions, right? Trent's laughing at me going, yeah, dumbass, right? Sorry, that's a word in our house. My daughter is 23 and my son is 19. And sometimes my wife and I look at each other and go, ah, dumbass. Lot and block, sectionalized, bounded by, strip, meets and bounds. You know, if you've been around long enough writing legal descriptions and helping clients and attorneys, and, you know, we've got the Pacific Ocean over here and the Golden Gate Bridge and stuff down south and, you know, San Diego. You know, you get into some really unique descriptions, and there are times where I get a little nervous about it. Am I going to really properly describe this light and air easement, you know, well? And I don't have any problem calling a friend and saying, hey, can you review this, or what are your thoughts? I know you've done a few of these. So that's the benefit of developing relationships, and the best place to develop those relationships are in forums like this. CLSA, NOWS, you know, all your organizations. lot and block. Here's some basic stuff. Looks like we've got about 15, 20 minutes. I'll just go through pretty quick. Provide sufficient data to locate the map. Believe it or not, I'm working on a project I started a year ago, and it says, be in lot 8 of the unrecorded subdivision of Strawberry Hill or something. I went, are you shitting me? So that's always fun. And just remember that if in your preamble you're saying, a portion of lot 8 of this subdivision map, and then you start your point of beginning, beginning at the northeast corner of said lot, well, that chunk might be taken out in a title report and then put into a grant deed, and your whole preamble is lost, right? If granting rights shown on the map, then say so. Provide more than enough information to properly locate the document. Be careful of quasi-public or unrecorded documents. The big thing with quasi-public is, they'll have a master map, but over time, they'll be like, oh, well, that wasn't right. And they'll erase something and redraw it. And now you base your information off of information of a map you saw 20 years ago. Thankfully, these days, we've got scanners, right? So you can get a copy of that quasi-public map. You can scan it. Maybe if, depending on the project, you can make that part of your recorded document. Of course, when you take that 24 by 36 scan and you reduce it down to an 8.5 by 11, some jurisdictions are going to go, yeah, it's an illegible document. We're not going to allow you to record it. So, aliquot. Transfer from government to private is patent, a lot like a lot and block, sort of. No, it holds federal rules, state law. California holds exact area when in private hands. That's always an interesting conversation. Without a survey, the client should understand potential locations. That's where you need to have a good discussion with your client about, I get it, this survey will cost 10 grand, 20 grand, but you're trying to get an easement maybe for your well in perpetuity that's critical to your property. Maybe we should spend that money and do a boundary survey. The Treaty of Guadalupe Hidalgo, that was an interesting piece of information, and I won't get too much into it, but in 1847, is when we started the process of that treaty. And in late 1847 or early 1848, we had signed, well, there it is, signed May 30th, the treaty, which essentially put that territory into U.S. hands. And I'll just give you a quick tidbit. I think we have a few minutes. I was doing certificates of compliance in the state of California. The state of California became a state in September of 1850. My client, right in downtown Sonoma, millions of dollars in property, they asked me to do certificates of compliance. They said, well, you got 3. I did a little bit of research, and I actually decided that I would challenge their city council, legal counsel, and go for 4 certificates of compliance. Here's the argument I used. There was a deed written in 1848 that described that original parcel on one of my ACCs as 2 parcels, the west 25 yards and the east 25 yards. And so what I said was, that was a legal parcel granted to the United States of America in 1848 through the Treaty of Guadalupe Hidalgo. And my client took possession of the property, or the heirs and successors, of course, in like 1851. And so they granted me the ACC because they saw my logic around this Guadalupe Hidalgo treaty, basically saying that was a legal parcel. And when the state of California became a state, how could they ignore this deed that was properly created under the United States of America? Anyway, it's one of those things where I just go, holy shit. And the legal counsel read it. And they actually agreed with me and gave them a 4th ACC. So I was like, wow.
Aaron,
Now
what
as a
do you think
surveyor, what's that, Rob?
what do you think that 4th parcel is worth?
About $1.3 million.
$1.3 million that you saved your client, you made for your clients on that deal.
Yep. Yep.
I hope your fee was commensurate.
You want to know something, Rob? It was free. And let me tell you why. I went to my client and I said, I would like to try this. There's no guarantees I'll be successful, but I wanted to understand if my knowledge and my approach was right. So I said, you pay the application fees, which was about $2,000, and I'll write my project proposal statement. It took me about maybe 2 hours to put all the facts. And my client agreed with me. And they said, sure, that's a good approach. And so I wanted it for professional satisfaction and to establish a precedence. So, Rob, after that, we've done all kinds of lot line adjustments and land development on the project, probably into it about $100,000 in the last year and a half. So sometimes, even though my education, formal education is in business and marketing and administration and all, sometimes I got to realize there's a lot of value in just having the ability to test theories, right? And hypothecate and have a client that's willing to go on that journey, knowing that there might be a little risk. Now, what the risk was for my client was, well, okay, you went for 4, it didn't work. We're still at 3 where I thought we would be. Yeah. So, and it's a great story to tell people that actually that treaty was able to get an extra parcel. So, bounded by, you become the most junior of the deed parcels. Verify your parcel is in fact junior. Research the adjoiners. A chain of title may be necessary. So just be careful if you're going to do a bounded by description. Sometimes those are a good way of doing it, especially when a client is insistent that they don't pay for a survey, they're on a limited budget, things like that. Where I get stuck is a lot of times is the compassion piece of it. Someone calls, they says, my mother is 80 years old, she's got to go into a nursing home and we've got to somehow sell the parcel and pay for that and all that. And okay, I get it. So maybe we're not doing the survey or other things, and we write these descriptions, but usually in my contract, I'll outline all of the risks associated with the direction that we're going to go. Because, we all have clients, they call you in 2 years and they go, holy shit, Trent, why did you recommend doing this stupid idea? And then you go back to the emails and you go, I told you not to do it, but you were insistent that you wanted to save a few bucks. And those are always great conversations. Here's your script descriptions. I love this. How many times do you guys still see this? 10 feet on either side of this described center line. I don't know. I think it's funny. Has anyone actually drawn an easement on their map and just chose a side just to play with someone and said, the first course will be the left, the second course will be on the right. And then you show this easement that goes back and forth and your client goes, what'd you do, schmuck? Yeah, well, it said either, I don't know. Felt like that side was best suited. Look at Trent laughing. It's probably like, yeah, I did that yesterday, Aaron. Is that a problem? No, it's a great conversation piece. You'll be on someone's slide in some seminar, somewhere, some city soon. Here's the big one. Has anyone ever not seen this statement and not extended it to the sideline when it's obvious it should? These are the little things I think surveyors get their undies in a bunch, right? They forget to write that statement at the end. And they come in at a 10-degree angle off of perpendicular. And the right side is 2 feet over the property line and the west side is 2 feet short of the property line. Has anyone ever said, well, you don't have legal access over this little triangle? It'd be interesting to know. But I think that's where we as surveyors, we need to understand, don't create a problem. If it's obvious that those sidelines should be extended, extend it on your survey. Maybe make a note. Say, hey, there wasn't a note that the sidelines should be shortened or extended to meet at the property lines, but I think it's obvious that the intent was to do so. Because if you don't, and it starts in with the attorneys, I don't know, I think at the end of the day, it's going to be the surveyors who look like an idiot after all the depositions are done. A lot of times I'll sit there and say, here an ending said described line, just so that people know that I am at the end. And because I'm always worried what title companies do to my documents. And if I'm worried about what they do to mine, then I should be really worried what they're doing with everyone else's. And did they truncate it somewhere, right? But if I see that sentence, it sort of says, okay, that surveyor intended for me to be at the end. Meets and bounds, bearings and distances, bounds, monuments, establish a clear basis of bearings. Ian and I and had a nice discussion about that. It's a great discussion. Go back to your next chapter meeting, and if you don't have a good topic to talk about basis of bearings for records of surveys, for legal descriptions, for all kinds of things. Just get people's opinion. I think people are afraid to give their opinion because they don't want to be shamed. I'm okay with it because in my mind, if I raise my hand and I say, here's my opinion on something, and 20 people come unglued and educate me, well, then what's the worst thing that happened? You know, I played basketball my whole life. And, you know, when I was in Europe playing, first I couldn't speak the language, so I didn't understand half the time what my coach was saying. But one of the assistants said, Aaron, would you rather screw up in practice where there's 10 media people and 15 of our coaches and teammates around? Or would you rather screw up tonight on national television? I'm like, well, that's a good point. So when I get into some of these forums, you know, I'll raise my hand and say, you know, I think this. Because I wasn't afraid. I know when I took Paul Cuomo's class before I passed the exam, you know, I went into it, and every time he said, can I have a volunteer? I raised my hand. And probably 70% of the time I was somewhat right in my thought process, but the other 30% I wasn't. And there might have been some people that walked out of that room and said, that guy's stupid. And okay, but I learned something because I was able to challenge my thought process, and I passed the exam that year. So again, I just want all of us to be working with one another. You know, I've heard from a bunch of people, and I see, you know, all different types of people on the call. Trent, you might have more extensive list. Wait a minute, maybe I'll pull down my participants. No, can't see.
Yeah, there's 18 on tonight. We had up to 20 at one point, but
yeah, so we got, looks like Trent, we got people from all walks of life, right?
correct.
And I just think what an awesome opportunity for us to just collaborate, right? Hear ideas and hear people's thoughts. Like I really liked hearing Steve right before I'm going to go into my meeting tomorrow. It's like, you know, I need to make sure I'm open and listening to this reviewing agency about my legal descriptions, because at the end of the day, I want what's best for them, but you know, I also need what's best for my client. And sometimes these municipalities are delaying projects, and when you've got a $10 million carrying cost on a project, just calculate the interest charge on that every month. And you know, if it was you, you might say something.
They're just protecting their interests. That's
Yeah.
in the story, right? I mean,
Make sure your calls are clear. Make sure you don't create conflicting calls. If you refer to other documents, make sure they are available. You know, I must
not that
have been
unrecorded
that,
map.
right? Like the unrecorded map, right? And you know, do not qualify to a plot, map, or document that is unrecorded or hard to get, right? And just, you know. So anyway, that's the end of my slideshow. And you know, if there's any other questions or dialogue? I don't know, you got 5 or 6 minutes.
Yeah. There was a good one that George put in there a little while ago, but once you develop your style, you can prepare your description. You'll just need to think about data and calls. It's a really good thing. Really good one there. And then Sean had asked a very loaded question early on, but
Hey, I can't hear you anymore, Trent. You're breaking up.
yeah. You touched on it just a little bit early, but how are significant differences between the legal description and the plat handled, just kind of generally, but he found a few this week where the curves didn't compute correctly. And so, kind of.
My opinion is if you can properly document and isolate the error, then isolate it and address it. I don't know what he's working on in a project, but let's just say he's going to file a record of survey at the end of the day. The record of survey is an awesome opportunity to just write a couple of notes and say, here's my thought process, and here is why I did something. If you're doing it, there's all kinds of reasons that, Sean, I don't know who you work for or if it's an agency or a state.
Yeah, I work for a state agency. So I was trying to rebuild this map from the 80s, and there was like a lot of non-tangent curves and stuff, and it just didn't work out. So
Yeah.
I brought it to the attention of my LS, and he finally worked with it, but he's like, it doesn't close for 5 feet. What do we do?
Survey it. Now you're going back to retracing, maybe finding some monuments or, it doesn't sound like maybe the surveyor who prepared that is accessible.
Yeah,
no. Was it a map from within your agency?
No, it's actually an outside map because it's in a butter to the property that we're surveying.
Yeah.
So we're trying to rebuild our piece based on all the abutters. And I'm like, oh my God, this doesn't work. And then I find discrepancies in the radius from one part of a map to another. And it was just a mess, and the legal description didn't really do it any justice either to help understand it. So
that is the situations we are faced with in the real world. And there's a whole slew of ways to start approaching it. And, you had another LS look at it, if that guy's records, see, back in the 80s, everything was computed, right? And then hand drafted. So it's not like there could be an AutoCAD file where someone could go, oh shit, those 3 curves were supposed to be non-tangent. I forgot to give the radial bearing. I don't know, there's all kinds of ways to start resolving that. But I think at the end of the day, if you take into account, all of the rights of the property owners, your agency's rights, the abutters' rights, and you try to solve this the best you can, and then you write some notes on your map about why, at least when I pick it up, hopefully you'll file a map. I know some agencies aren't required to file it, but boy, if you can document this problem and put something on file, then if your state agency says, well, we don't have the $1,000 budget to put it on record, well, tell your boss to kiss
and that's
my
exactly
ass.
that's exactly what I did. I made note of everything I did. And, I'm just learning this stuff kind of for the first time, but I'm picking up these errors. And so he's like, the best thing you can do is just make note of these things and just try to work through it. And yeah, that's pretty much it. So
are you guys going to file a map on that?
It's not going to be a certified boundary map. It's more of a plot plan. So we're just kind of putting our line work on there for the parcels, boundaries, but currently it's not being certified to any boundary. So
if you can file a map on that somehow, or just something on record, along with your notes on what you did, you have probably a 90% chance of the next surveyor that comes along and discovers that problem of agreeing with your solution, or at least looking in that direction. And that not only saves that surveyor time, it saves their client and everybody else time and money.
Yeah, I think that's the direction that we're going to end up going. Of course, that's up to the LS to make that decision and go that route, but it was discussed. So yeah, it looks like it's going in that direction.
Sean, let me just echo what George said is, the next surveyor is going to have the same problem you did. And how many hours are they going to spend going, what the hell? And could you imagine if you knew that 2 years ago, another surveyor had the same problem and wrote some notes and identified it, you at least wouldn't have gone batshit crazy for the last 2 weeks figuring out, what am I doing wrong? Because we've all been there, right? And so now you can put it on record. And if you use sound judgment and professional judgment, as George said, I don't know, I'm going to be hard pressed to disagree with you as long as everything seems logical, because I don't want to start creating conflicts, right? So George, you know, I 100% in agreement with you. And maybe you can talk with that county surveyor and say, hey, we want to just kind of document some information more than document a boundary resolution. And, you know, they probably will be a little more acceptable to what data is actually on your map and not, you know, hold your feet to the fire on certain details and critical elements.
Yeah, Aaron, I was just going to echo exactly that. If you can talk to your county surveyor, if you're in Alameda County and you came in to talk to me and said, "Hey, look, here's what we found. What can we do to get this thing documented?" I'd figure out a way to do it, even if I put together a corner record, record of survey for you and filed it under my name after we got that information together.
Yeah, we got to get good information into the records, right? I mean, just get some thoughts, and so we can at least evaluate it. If we don't know what to evaluate or that there's a record out there to evaluate, you know, we're just kind of staring in the dark.
Well, and we're all in this miserable game together, which I happen to love. And the more we can help each other and respect each other professionally, the better off we're all going to be.
Yep.
Which, you know, wasn't happening 50, 60 years ago, right? And that's why we have some of the problems we have now. So, you know, to move forward, this is some of the great advice right here at the last 2 minutes. So this is good.
So Trent, are you suggesting that Steve Parrish didn't have email back in the 60s? What are you suggesting?
There's an exception to the rule, because you know darn well Mr. Parrish would not have any of these conversations we're having right now. That would not be a conversation behind it.
And I got to tell you, Aaron, I was lucky enough to work in the same office with Steve in the private sector after he retired from BLM. And I learned a tremendous amount from that gentleman. And I still consider him a close and valued friend. He's even though he's moving to Idaho.
That's right.
Yeah. Now, Steve, you know, that's another relationship. I've called Steve on 4 projects and you know what? Every time, never once did he say, "No, I don't really have time for this." Never.
Nope.
And his input and advice was able to help us navigate what could have gotten ugly between very wealthy vineyard owners to something that was a good solution. So hats off to Steve. He's another champion of our profession. I love the man.
That's right.
The word no does not exist in his vocabulary as far as helping someone with a survey.
No.
And I mean, he will leave literally no stone unturned, no pun intended.
No kidding. Yep.
Trent, do we have any other comments in the chat box or anything?
Nope. I think that was about it on there, but you definitely hit it, you know, quite a few times tonight, and that's most important thing coming out of even today from your advice is create that professional network, you know, and lean on your professional network. And so that was one of the things that I kind of wanted to do, even with Mentoring Mondays when we first started, was give them that open forum for people to just come in and ask questions, like just like we had tonight. And so it's good.
And challenge yourself. Challenge yourself.
Absolutely.
To think about ideas and ways to do things. Challenge yourself. And then use others. If you work in a small office where it's you and your boss, well, develop a connection with someone else. Or you know what? If you're on here and you're not sure who to turn to, okay, I'm going to tell you right now, email Trent and say, this is my geographic region. Because Trent, you know people all up and down the coast.
Yep.
And just reach out to someone and say, is there someone in my area that you think I could lean on and learn from?
I was lucky enough to work in an office that had 9 licenses, all PLSs. And so if you ever had any question about what you were doing, if you had any sense about you at all, you took whatever you were doing and had it looked at by 2 or 3 people in that office before you ever turned loose of it. And well, I'll tell you what, it saved a lot of heartache and a lot of problems.
Yep, exactly.
Well, and if you join your local association and go to meetings, even if you have one LS in your office, you have access to a whole bunch of other LSs at the association. And I don't know of any person at any of the association meetings that I've ever been to that I could walk up to and say, hey, I've got a situation here. Can I pick your brain? I don't know any of them would look me in the eye and say, no, piss off.
Oh,
And if they did, you know what to deal with it, to do with them. I went to my first CLSA meeting the second week I was ever surveying for Larry Paxton back in '88. Through CLSA, I have met tons of people, including Aaron and Rob McMillan and God knows how many people. I have graduate level. I don't have a degree in land surveying. My education is all in chemistry and human biochemistry, but I have a graduate level degree from conferences and CLSA meetings, sitting around and having beers with guys like, oh, I don't know, Gurdon Waddle, or no, I'd never met Gurdon, but Kurt Brown, Mike Palmieri. The only regret that I have in surveying is that Kurt Brown died the month before I got my pass result back from my LS in '93.
Good stuff.
That's the way. And just to be clear, Ian didn't say he got a graduate degree in beer drinking. He just said he would have beers while getting the graduate degree.
There you go. Go for it, Rob.
The beer drinking graduate degree as well.
There you go.
Hey, Aaron and Trent, George asked a question on the chat early on, and I think it had to do with Aaron putting more information in the body as well as the preamble. Aren't the title companies supposed to file the legal description as prepared by the land surveyor, since he has to stamp and sign as the author of the description? And my understanding of the situation is, yes, that's correct. They do record the documents, but it's in the follow-ups later on where they're doing a preliminary title report for somebody and they're just capturing the body, right?
Yep, exactly. That's it exactly, Rob. So you can always go back, to the original description and research that. But, a lot of times that doesn't, you don't have time or you don't know where to start. And sometimes the research is difficult. So I always take it as if my body got cut out, could someone have a fighting chance on properly locating it just based on that? Yeah.
Good stuff. Any last second questions? Would definitely be respectful of Aaron's time. He's hungry. It's dinner time.
I had my calories.
There you go. You had a couple. You burned off a few earlier.
Hey, I'm just getting excited about next year's joint conference down in Las Vegas. Yeah. And everybody on this call should be there.
Yeah.
And what are the dates going to be there, Trent? Is that March 29th through April 2nd? Does that sound right?
Sounds right. Yeah, I think it's March 30th or something, but yep, very end of it.
Is the swimming pool done yet?
No, they haven't been there like a week and a half. What the heck?
It'll be
done by March.
It'll be ready for March. That's right. It'll be ready for March.
And
was
only a single malt.
There you go.
Yeah.
All right.
Was there any last questions in your chat?
Nope, I think we're good. Just lots of thanks. Thanks for your time and putting stuff together for us. So.
No, Trent.
Thanks, Aaron. Great job. Good info.
Yeah, thanks, Aaron.
Yeah, you guys are welcome. I was glad I could be part of it. Trent, thanks for.
Of course.
Great to see you.
All right. Have a good night, everybody.
Thanks, everyone. We'll see you.
Good night. Great job, Aaron. Thanks.
Sounds like it went well.
It always does.